man like this doesn't know the law. You don't know the law. Why is it when it comes to my case, they turn the law upside down? They turn the law upside down. Upside down. Upside down. This is the laws of Nigeria. The prosecution and this court doesn't know the law. That is the fact.
Yes.
Poor knowledge of the law is killing Nigeria. Poor knowledge of the law, they don't know the law. This is a federal gazetted law of Nigeria that says here that the chief judge of Nigeria cannot tell Binta NYAKO what to do. It's here. It's your law. Just obey it.
The order of adjournment by Justice Binta NYAKO is nullity. Again, I repeat, the order of adjournment by Justice Binta NYAKO is nullity. What d-NNAMDI KANU was simply asking is you to obey your own laws, act by the provisions of the Nigerian Constitution that borders on the Federal High Court laws. The laws are there. The laws are not ambiguous. The laws are very clear for the chief judge and the judge who eventually voluntarily recused herself of continuing the trial of d-NNAMDI KANU suddenly resurfaces again without any recourse to the position of the law that established the Federal High Court judges. It's quite very ridiculous and unfortunate. This informed the reason why d-NNAMDI KANU said, how can an old man presiding as the chief judge, by that description, he is saying, you have been in this system before you become or attain the position of a chief judge within the Nigerian legal jurisprudence. It means you have been practicing law for quite a good number of time or years, because it is not just an all-commerce affair. Now, he is referring, by virtue of your experience and time you have spent in the courts of law, to be acquainted with the basic principles that guides the operations of the law, where an accused person have doubts about the integrity of the presiding judge, to the point that he speak out, made it very clear that he has no confidence. He no longer reposes confidence in Justice Binta NYAKO on the basis that she has compromised, she has been induced, and he cannot get justice. Justice Binta NYAKO cannot deliver justice as he expected. That ground is enough to disqualify or discontinue Binta, or for Binta to withdraw from that case. The defendant has the right to demand that the judge presiding over his case or her case should be recused, which eventually Justice NYAKO Binta eventually voluntarily recused herself, which means she has lost the jurisdiction to continue the trial. She has disqualified herself under the law, under the provision of the law. She can't continue with that case. She disqualified herself by voluntarily recusing herself based on the demand of d-NNAMDI KANU. How suddenly you could now summon d-NNAMDI KANU again to resume the same trial, which he have expressed that he has no confidence in you presiding over his case, that you have been biased and have compromised the process of fair hearing and justice. So this is a very good ground for Mazi Nnamdi Kanu to, of course, maintain his position that he could no longer be subjected to any form of trial under the supervision of Justice Binta NYAKO. I think that was very plain and very clear enough for those who believe they are practicing law. They have been, of course, within the premise of the law and who understood the implications of the law. It's quite embarrassing, and that is very shameful, and that shows that Nigeria is gone. We no longer have a country. We no longer have a country as Nigeria. If the judiciary, who should uphold or considered to be the custodian of the law, could be behaving in such a manner in contradiction with the position of the law. Now, the Federal High Court's Act stipulates this. Let's read one of the extracts from the Federal High Court Act. It says thus, just follow me. Hope this will be very clear. Okay, let me see if I could adjust that. Okay, let's get on with that. It says a judge of a court may at any time or at any stage of the proceeding in any cause or matter before final judgment, either with or without application from any of the parties thereto, transfer such cause or matter before him to any other judge of the court. So the judge have the right to recuse herself from proceedings, from continuing with any criminal or civil proceedings or matters before the determination of the final judgment, of which Dr. Binta understood the position of the law and recused herself because her integrity is at stake. Her integrity is being questioned. Her sincerity to dispense justice is being questioned. That alone disqualifies her. In a sane and responsible society where we have people who adhere to the rule of law, there wouldn't have been any need to begin to make or attract unnecessary attention regarding this position. What the chief judge would have done is to assign this case to another judge. After all, of course, in a court you have, like the High Court, you have not less than 50 judges. So if one has recused herself because of the doubt expressed over her integrity, which is questionable according to the submission of the defendant, then what are other 49 doing? You could assign across, as even the lead counsel to Mazi Nnamdi Kanu has admitted or requested, that if you don't have any judge to assign the case, rather than returning Binta NYAKO, what you should do is to, of course, refer the case or shift the case to the southeastern region, where, of course, there will be available judges to continue the trial if that is deemed necessary. Because for me, I don't see any reason why the continued trial of Mazi Nnamdi Kanu should be backed by Nigerian government, just as Omowole Sowore submitted. He said the government of Nigeria should stop wasting the common resources of the people in the trial of Mazi Nnamdi Kanu. He should be discharged and acquitted according to the provisions of the law. There is no need trying to buy time. It doesn't solve any problem, but it portrays Nigerian to be corrupt, fantastically corrupt, even in the judiciary. No wonder Dele Farotimi, who happens to be a legal practitioner, luminary even within the Nigerian legal jurisprudence, have indicted the Nigerian government on the book he wrote. He expressed his own opinion and experience encounters and frustrations in the course of dispensing justice for his own prospects and clients. He wrote a book, Nigeria and His Criminal Justice System. This informs one of the reasons why he has to compile his experience, and it was a compendium of his experience and frustrations and what he considers to be the rottenness, the corruption, and irregularities within the Nigerian legal jurisdiction. Justice Bicha NYAKO eventually, by voluntarily recusing herself, has lost the jurisdiction, has lost the right to continue the trial or to further attempt to d-NNAMDI KANU's case. On this basis of the law, I hereby submit that the order of adjournment given by Justice Binta NYAKO over d-NNAMDI KANU case is nullity. It is embarrassing. It is unacceptable. It is a mockery of the judicial system and the judicial process. In fact, of course, Nigerians should be ashamed of what is going on within the legal system. That means there is no hope, there is no sanity, of course, within the system. Binta and the chief judge or whoever is involved would have saved Nigerians from this embarrassment. It's a national embarrassment that d-NNAMDI KANU have to stand his ground, because he is lettered, he understood, he is informed, even citing the provisions of the Federal High Court Act, that the chief judge has no right to interfere, to influence the position of the judge. And this is very clear. So any other person could have felt the same way d-NNAMDI KANU felt. So why should we be turning the law upside down? Why should we be changing the rule? I mean, these are gazetted laws, spelled out, that everybody has access to. Does it mean that those judges or the chief judge does not understand the position of the law? Then how did he manage to become the chief judge, presiding over an entire legal jurisprudence or jurisdiction? It's quite laughable and very unfortunate. So you don't have to blame d-NNAMDI KANU. Of course, he made a very strong assertion that I have the right under the law to advocate and agitate for the sovereign state of Biafra. Nigerian Constitution, as amended by 1999, as amended, recognizes the right of individuals or group of persons to political and affiliations, and to in pursuance of their own fulfillment, and they have the right to choose, to freely choose their own affiliations, who to identify with or not. And of course, Nigeria being a to the United Nations Charter on Fundamental Human Rights and the right to self-determinations, I think that part of the charter shouldn't be alien to Nigerians and the Nigerian government. It's very unfortunate. This is another embarrassment to the Nigerian judiciary, and it's very unfortunate. Each time, each passing day, people begin to lose more confidence in the legal system, Nigerian legal jurisprudence or jurisdiction or legal system. Is quite very unfortunate. So d-NNAMDI KANU was right, of course, that he never expected you should come with clean hands. You should be impartial regardless of any interest or pressure that is coming anywhere. A judge or a chief judge should be considered to be impartial, not siding, not compromising, because you are meant to defend the integrity of the law, to uphold the Constitution. But unfortunately, what we are seeing is very unfortunate and laughable, if I may say. It is quite laughable. So adjourning the case indefinitely is nullity, because you have no jurisdiction. I think that set the record straight. You have you have disqualified yourself the moment you voluntarily recuse yourself. You can't come back again to your own vomit. I mean, that is quite very disgusting, if I may say, because it insults the intelligence of the listeners, of people watching all these things. And what is exactly happening? Are these people children? Why are they embarrassing themselves and the Nigerian state and their listeners? Well, let's have your own take regarding this development, and we are coming with more analysis of what transpired yesterday about bordering on d-NNAMDI KANU case.